Good afternoon, everybody. I'm Jeff Gleason. I'm a member in our Buffalo office in our business group, focusing on transactions among business entities. Sophie, if we can go to the first slide, we can start here. If any of you were on our webinar 2 weeks ago, the first session, I just wanted to provide a refresher for what we went over there. The slides are available on Bond's website, and we're more than happy to talk through the content of those slides with anybody offline. But just a refresher from session one, some of the things we went over were the choice of entity when you're going into forming a practice. We talked a little bit about the corporate practice of medicine and how that works into how you choose to form the entity that is intended to practice whatever area of specialty you are in. We talked about private equity concerns and how private equity actors are active in the market of acquiring medical practices, dental practices, and other kinds of clinical practices. And especially how that intertwines with the prohibition on the corporate practice of medicine. And then towards the end, we touched on a little bit succession planning within your own practice, whether that involves, ultimately selling off to a private equity actor or merely handing over your practice to the next generation of doctors. Again, I'd like to put out, a caveat. We're going to talk a lot about physician practices in this webinar. When we use the term physician, when we use the term practice, we are intending to capture, any clinical, medical, or dental practitioners to whom the New York State licensing laws apply, so we'll use physician as shorthand for any kind of those clinicians. Again, we touched on succession planning last time, with a focus on private equity transactions. We're going to talk a little bit here about agreements among equity holders and how those impact your practice, how you can use those, again, to maximize value and to reduce risk in your practice. So if we can fast forward to the next slide here. So agreements among equity holders, what do we mean by that? There's obviously a number of different kinds of agreements that owners of a practice can have between them, but really we're going to focus on a couple here. And focusing on these does not necessarily mean addressing every facet of these agreements. There are hundreds of permutations that even just these three can take. We're not going to go into all of them, but obviously our attorneys here at Bond are happy to talk through kind of the impacts of different choices, a little bit of a choose your own adventure as you're looking at putting one of these in place within your practice with your partners. We have a shareholders agreement. When we talked last time about choice of entity, obviously you may choose to be formed as a professional corporation. If you're going to put in place an agreement among the equity holders of the kind we're going to talk about here, that would be a shareholders agreement. If you are formed as a professional limited liability company, it is recommended, it is almost necessary to have an operating agreement. And that operating agreement is the contract among the partners as to how your PLLC will be run, how it will be governed, how money will come out of there. You may also, kind of not have a very complicated or complex agreement addressing a number of scenarios. You may only have in place a buy-sell agreement, which if you have two owners of a practice, this may be the path you go down. All it does is impacts, how one partner may buy the equity of another partner. But again, stepping back, what are we trying to address with these agreements? So, some of these things that these agreements try to get at are management and decision making. These could be just day-to-day decision making, who's in charge. It could be the appointment of certain people to carry out certain tasks. It could be things, major things that may happen in the life cycle of your practice, which would require supermajority or unanimous approval. We typically refer to these as protective provisions, protective of the individual physicians or the individual, kind of minority holders of equity, so that they can be a part of those decisions, or they cannot be left out of certain decisions. These agreements may address bringing in new partners to the business. How do you issue additional equity to a new member, a new shareholder in this practice? They'll often also address distribution of funds. Obviously, that's very important to everybody. We all want to get paid. That's why we run businesses. And the distribution of funds, particularly when we're talking about an operating agreement, can set the priority for the distribution of those funds. It could also include tax distributions. If you've ever been in a position where you get to tax season and you don't have enough cash in the business to push it out, you've known that there is, potentially an issue with having income on your K-1, but no actual cash to pay those taxes. And then lastly, these could deal with dissolution and the winding up of the business. Obviously, that's something that comes down the road, something that a lot of people don't like to think about right at the outset of starting one of these practices. But it's something that we do recommend you address in one of these agreements, so that if you get to a point in your career where you want to step away or shut down the practice, you have those procedures set forth and agreed upon among the equity holders. Next slide, please. So we talked about kind of what kind of agreements we are addressing here, but obviously this series is about maximizing value and reducing risk. So how do these agreements help maintain value, help maximize value, help reduce risk? First, they ensure continuity and ownership. If your practice is one that you expect to outlast your career, you need to have procedures set forth in these agreements in order to hand over the practice to the future generations. And this is not necessarily just a successive process. It could be an ongoing process. Again, bringing in new partners as people are coming out of medical school or dental school. It could be, bringing them up through the ranks of an associate within your practice into full partnership. It provides mechanisms for resolution of disputes. If you've ever, had one of these disputes, you could get to a point where, you're just at loggerheads with your partner or partners, and without one of these agreements, which sets forth the process for resolving those disputes, who gets to make the final decision, who has the final say, you might just be at a place where you can't go forward, you can't make a decision at all, and so, kind of that's really a less than advantageous position to be in. Also, you may want to provide for the punishing of wrongful conduct. If it happens, sometimes there are partners in a business who you need to separate yourself from, and having a process by which you can, for lack of a better term, push them out of the business. It's again, you could just be in a position where you're having to go to court to sue them, or to kind of resolve those differences through court, as opposed to doing it behind the scenes, having it be less than public. Obviously, a public dispute can really harm the value of your business. Next slide, please. So, going on that last point, one of the things that we really try to focus on when we're talking about either starting a practice from scratch, and at the outset putting in place a shareholders agreement or an operating agreement, or even further on down the line, if some of these provisions aren't in your agreement, having these addressed, are mandatory transfers or sale of equity upon the occurrence of certain events. And this isn't always the easiest conversation to have, because when you're going into business with your partners, everything's kind of rosy, everything's good. You don't necessarily want to talk about what happens upon the business divorce. But we really recommend having that conversation, having kind of broaching those topics right away, so that you can have an agreement upon one of these things happening. Obviously, death or disability, retirement, these aren't really controversial topics, but having an agreement upon what happens to your equity, to your ownership of this practice upon the happening of those events is important. Does the company, does the other partner or partners purchase your ownership interest in that practice? Is there some valuation to it? These are all parts of this analysis. Voluntary withdrawal, similar to retirement, you're just kind of stepping away. You don't want to be a part of this practice anymore. You may or may not be going on to practice individually or with another practice. Involuntary dissociation and morals clauses, these are the ones that really are the more difficult conversation. Involuntary dissociation is something that, an event happens and that provides rights to the company or to your partners to effectively push you out. This could be the failure to maintain privileges at hospitals in which the practice works, or other facilities, the suspension or revocation of your license to practice medicine or dentistry, the conviction of or a plea of no contest to certain crimes. This could be just the vote of a certain percentage of your fellow partners that want to push you out. Obviously, that one gets a little trickier, right? You haven't done anything wrong. You just disagree with the people that you're in business with, and so this becomes a difficult thing to negotiate up front. Combination of any of the foregoing. You could have something like a morals clause. This is a kind of subjective view of something you did isn't really good for the business. And again, when we're talking about maximizing value and reducing risk, this is something we have to consider. What are the actions that one of your partners could take that could really harm you in the business? Definitely something that you should think about having in your agreement. This can be automatic. It could be drafted as an automatic offer of your ownership stake in the company back to the company or the other partners. And there may even be a mechanism for redistributing the equity to the current owners. This is kind of more seen as bringing on the next generation of partners. Usually upon the retirement or death of a partner, you may say, well, that just gets absorbed back into the company, or we bring in the next person in line. This is bringing along those associate doctors within your practice. Next slide, please. So, again, we talked, what are these triggers, but, kind of what are the mechanisms for preserving the value in the business when one of these things happen? Again, how does it occur that one of the partners leaves the practice and we do everything we can to preserve the value within the practice? How is that equity valued? There are a lot of different ways that you can go about this. You could have an annual process by which the partners agree on a value. There could be some certificate that everybody signs once a year that you say this is the value of the total business. And when you have an event of dissociation, you assess that person, the person's ownership interest at that agreed upon value. You could have at the time of any of these events happening, a third party valuation come in. Another thing to consider, is there a punitive function? For instance, in those events of involuntary dissociation, somebody actually took an action that is harmful to the practice, or is viewed as wrongful. Is there some discount given to, kind of what the price is that the company or the fellow partners need to pay to that dissociated partner? In some instances, you may choose to fund the purchase price for the equity of a deceased partner with life insurance that gets paid to the company upon that partner's death, and then the partner or the company then turns over the life insurance proceeds or some portion of it to the estate of the deceased partner in exchange for redeeming their equity interest. A lot of times you have a provision in your shareholder agreement or operating agreement where some or even no money is paid up front for the interests of the dissociated member, and it's all paid on a promissory note. This is a way to not liquidate a bunch of cash out of your business in order to rid the practice of this dissociated partner. And then, of course, we have other concerns to preserve the value of the business. What happens? What obligations are we going to place on that dissociated partner after they leave the practice? This is when we get into non-competes and restrictive covenants. So, that's what Brad's going to talk about next. But, just one thing to remember, it's never too late. Just because you don't have a shareholders agreement or an operating agreement in place at the formation of your practice, you can always have one of these put in place later on, or you can renegotiate your existing agreement to contemplate some of these provisions. We do recommend that you talk to an attorney, look at these agreements regularly to determine if there's some adjustments that need to be made in order to use these parts of the agreement to preserve value, maximize value, and reduce risk in your practice. And with that, I'll turn it over to Brad.
Thank you, Joe. Good afternoon, everyone. My name is Brad Hoppy. I'm a member in Bond's Buffalo office. I'm a commercial litigator with an emphasis on non-competes and trade secrets. And today we're going to talk about the use of non-competes and other restrictive covenants to protect your business. Next slide, please. And here's kind of the subtopics that we're going to cover in this part of the presentation. We're going to talk a little bit about, restrictive covenants in a more general sense. Then we're going to move on to kind of an update on the FTC's non-compete ban. And finally, we're going to talk about the New York rule for enforceability when it comes to your restrictive covenants. Next slide, please. Just fast forward to the next one as well. So these are kind of your types of restrictive covenants in general sense, right? We have our non-compete, which is going to prohibit, an employee, a partner, from competing either during employment or after employment is over or after the business relationship ends. The second, we're talking about your non-solicitation covenant. This can have two forms. It could be a customer non-solicit, which would prohibit that employee partner from soliciting or doing business with customers. And the second one is your employee non-solicit, which prohibit that employee partner from reaching out and trying to hire or solicit for employment any employees of your business. And finally, the non-disclosure confidentiality provision, which is a prohibition on using or disclosing confidential or trade secret information either during or after the employment or business relationship ends. Next slide, please. All right, so why do we want them? Well, this is about preserving value of your business, right? We want to make sure that, the intangible assets of your company are fully protected. And that's why you want to have restrictive covenants in all of these agreements, whether it's a shareholder agreement, whether it's an equity agreement of a different type, whether or not we're talking about an employment agreement. You want to have these provisions in place to protect the trade secrets and confidential information of your business, protect the goodwill, protect customer and patient relationships. But it's not just that. It's not just about enforcing these covenants in the event that you have to. You want to have these provisions in place so you have an effective deterrent, so you don't get to the point where you actually have to litigate anything. And that's why it's important to have narrowly drawn covenants where you feel comfortable that if push comes to shove, you actually can enforce them. Not only that, but you want to build in other provisions to these agreements so that employees, partners, think twice about violating the restrictive covenants. And just some examples here of the type of deterrence that you want to build into your agreements. You could have a provision in there that requires the return of certain compensation paid. You could have a provision in there that provides for attorney's fees or costs in the event that litigation is pursued. There could be a provision in there that the employee partner is agreeing to injunctive relief in the event of a breach. You could have liquidated damages provisions in there. One here is Defend Trade Secrets Act remedies. If you put in a certain provision in your agreement and the employee partner is found to have absconded with confidential or trade secret information, you could be entitled to triple damages, in addition to some other relief that you wouldn't otherwise be entitled to. Next slide, please. So I'm going to go over just briefly, in a little more detail, each of these types of restrictive covenants. I'm going to start in reverse order with the non-disclosure covenant. Obviously, this is designed to protect confidential and trade secret information. It prohibits both the disclosure and use of that information without authorization. Some other key terms that you want to include in your non-disclosure covenants. One, making sure that you have a provision in there for the return of information and company property at the termination of employment or the business relationship. You can also take it one step further and require that employee or partner to sign a written verification under oath to the effect that that information has been returned or destroyed. You could have a prohibition on the use of personal cloud accounts. I like to call these USBs in the sky, these cloud accounts. They're pretty dangerous. If they're not monitored and there's not a provision that prohibits the use of them, any information that's uploaded to a personal cloud account, there's really no way to track it. So that's something that you want to include in your non-disclosure covenants. And finally, I talked about the Defend Trade Secrets Act. There's a required provision called a whistleblower immunity provision, and having that in your agreement in connection with your non-disclosure will give you those types of remedies that I just went over a moment ago. And finally, when you're talking about a non-disclosure, it's not about just prohibiting an employee or a partner from using or disclosing your information. It's also about showing a court that you've taken reasonable steps to protect your information. Because if you haven't taken those reasonable steps, the court will never find something to be a trade secret and will never give you the protection that you didn't bargain for yourself. Next slide, please. All right, next is your non-solicitation covenant. Like I said earlier, there's two types. There's your customer and then there's your employee. We'll start with the customer. It's designed to protect your customer relationships and your goodwill. For a lot of companies, this is going to be one of your most important assets. You're talking about a physician practice, you're talking about your patients and the goodwill and relationships that you built with those patients over time. You don't want a physician just to go out after employment ends or a partner after the relationship ends and be able to exploit those relationships to the benefit of a competitor. It does prohibit solicitations of customers or patients in New York. Now we're talking about New York, with whom the employee had a business contact or developed a relationship with. If you try to include in your non-solicitation something broader to include all patients, all customers, that's likely to be found to be unenforceable and overbroad. And finally, I note here that it doesn't typically extend to customers or patients that an employee or a partner had a pre-existing relationship prior to that business relationship. Next is your employee non-solicit. That's going to protect against the solicitation or hire of the employees of your practice. Now, when it comes to non-solicitation covenants, these are obviously narrower in scope than a non-compete. So courts do routinely enforce them so long as you do this in compliance with applicable law. And we'll go over what that means in just a minute. Next slide, please. And finally, a non-compete covenant. This is the broadest covenant that you could bargain for, and it's designed to protect against a couple things: the use of confidential and trade secret information, competition from unique employees, and even to protect against kind of the goodwill being lost, right? A non-compete can't be used simply for the purpose of stopping competition. It's used for the purpose of stopping unfair competition, okay? Courts will closely scrutinize a non-compete covenant. They are disfavored in the law, but there is one big exception to that, and that's when it's ancillary to the sale of a business. We'll talk about that in a few minutes. Courts are far more deferential when it comes to non-competes in that context. Next slide, please. And just what I want to talk about briefly is the employee choice non-compete. This is a type of non-compete that courts look at a little bit differently than one that's done as a condition of employment. This applies where an employer conditions receipt of post-employment benefits upon compliance with broad restrictive covenants. So it basically provides an employee a choice. You could either accept the benefit or you could forfeit that benefit and compete. There's definitely advantages to this. It allows for broader non-competes where a court doesn't look at it with as close of scrutiny. But the disadvantage is it's only an effective deterrent if the benefit conferred is so valuable that an employee wouldn't want to risk losing it. Also, you need to keep in mind that if you rely on the employee choice doctrine as a means to get a non-compete, your remedy is going to be the return of the benefit, and it's not going to be injunctive relief. So if you're looking to stop employment, then this is not the means to do it. Next slide, please. All right, so now we're going to talk about the FTC non-compete ban. I know this has gotten a lot of press over the last 6 months, and rightfully so. Next slide, please. So this was an attempt by the federal government through regulation to basically ban the use of non-competes in the employment context. Now, there are certain major exceptions to this, including a non-compete that's entered into ancillary to the sale of a business. But when you're talking about a worker, and that's broadly defined under the FTC's rule, it's almost an across-the-board ban on the use of non-competes in that context. It would also ban the use of de facto non-competes, which, according to certain other parts of that regulation, you could see that would expand and include broad non-disclosure provisions, broad non-solicitation provisions. So if this went into effect, this would obviously be a major problem for a lot of businesses. The effective date on the ban was supposed to be September 4th, 2024. Fortunately, that ban never went into effect. Next slide, please, and we'll talk about why. Case of Ryan LLC versus Federal Trade Commission. This was a district court case in the Northern District of Texas. The plaintiff there brought an action to invalidate the ban on numerous grounds. The district court, after first issuing a very narrow injunction, granted summary judgment to the plaintiff on August 20th, striking down the FTC ban on the grounds that it was done in excess of congressional authority and was otherwise arbitrary and capricious as a matter of law. Now, what that means to you is that that FTC ban that was supposed to go into effect September 4th did not go into effect. And until a circuit court or the Supreme Court says otherwise, it will not go into effect. Now, this is going to be appealed. It's being appealed to the Fifth Circuit Court of Appeals, which is a very conservative court. So we have optimism to believe that this decision will be affirmed. And then at that point, it would go to the United States Supreme Court, which we have seen recently with other agency action, is not nearly as deferential to that action as previous Supreme Courts. So, obviously it's speculative at this point, but, we have a reasonable degree of confidence that the FTC ban will not go into effect in its current form. So that's great news. Next slide, please. What does that mean? Well, that means that non-compete agreements, like they were prior to the FTC ban, are going to be governed by applicable state law. And we're going to go into just a few minutes what that New York law means. But it is important to note that New York law obviously is not the only state law out there when it comes to restrictive covenants. There are certain states that ban them entirely. California is a great example of that. Oklahoma, Minnesota, South Dakota, those are the states that banned them in their entirety by statute. And there are a lot of other states that restrict the use of non-competes and have income-based thresholds for the use of non-competes. And there are too many to name, but there are a lot of states out there that do that. New York is not one of them. So let's move on to the next slide. All right, now let's talk about the New York rule for enforceability. Next slide. All right, so like any contract, sufficient consideration is required to enforce a non-compete. A non-compete, I'm going to use that loosely right now. That's a non-compete, non-solicit, non-disclosure. In New York, it's sufficient to condition, a non-compete on initial employment. Continued employment is another thing that the courts have recognized as sufficient, though this is more disfavored than initial employment. A promotion, severance benefits, any additional consideration that you can give in connection with the restrictive covenant is going to help when it comes to enforcement purposes. I noted here termination for cause versus without cause. And the reason that I included that in the slides is that there's a different rule in different parts of the state of New York when it comes to a termination without cause. For anyone that's attending downstate, your rule is a little different than up here in the Buffalo area. Courts have found downstate that a termination without cause renders your non-compete unenforceable. And in Buffalo, it's the opposite rule. It still is enforceable, although it's relevant to the equities when it comes to an injunction. So that's something that I think the New York Court of Appeals is going to have to resolve, because that is a conflict in appellate authority in New York. And finally, more is not better. You cannot buy longer or broader restrictions with more consideration. All that matters is whether or not the consideration is sufficient. Next slide, please. All right, the next part of the rule in New York is that your non-compete must be reasonable in time and area and no broader than necessary to protect legitimate interests. There's a lot there, so let's unpack it. As far as time and area restrictions, 1 to 2 years is generally considered enforceable in New York, although it still is fact specific. So it's still going to depend on a number of different factors. But, if you're at the 1 year mark, you're probably okay. 2 years, you might be pushing it depending on the circumstances. The geographic area, that is very fact specific. It's going to depend on the geographic footprint of your business and the employee or partner's responsibilities. When we're talking about physician practices and we have a non-compete that's going to be restricting a physician from practicing, a lot of times you're looking at very, very small geographic areas that can be restricted, because a lot of these practices are dealing with patients that are in a very small area, right? 5 miles, 10 miles from where that business is located. So, you need to be very careful about that, because for a lot of physician practices, if you try to expand that to an entire county or multiple counties, a court can find that to be overbroad and strike that down. So be very careful about the geographic radius that you're including in your non-competes. And finally, the legitimate interests. In New York, there are 4 that are recognized. The first is your confidential information and your trade secrets. The second is goodwill of the business. Third is the customer relationships or patient relationships. And finally, a key unique employee, protecting competition from that very small class of employees. In New York, actually, certain physicians are considered to be key unique employees by case law. It's not going to be everyone. It's not going to be your general practitioners, but certain specialists are going to meet that definition. So in those circumstances, you're not going to need to rely on trade secrets or confidential information or customer relationships. You could rely on just their role in the business and the specialty that they have. Next slide, please. And the last part of the rule in New York is that your non-compete cannot be harmful to the general public and or unreasonably burdensome to the employee. So you need to look to the hardship that's imposed on the employee. And a lot of times, I mean, if you're going to meet the first part of this rule where it's no broader than necessary to protect a legitimate interest, then I don't think you're going to have that much of an issue meeting this part of the rule because, it's not going to be an undue hardship if it's narrowly tailored. Same with public policy. It's going to be rare that you're going to have a restrictive covenant that has an issue from a public policy perspective if you're meeting the other parts of the rule. All right, next slide, please. Now, I noted earlier that in New York, there's a different rule for a non-compete in the sale of a business context. And this is the rule and this is the standard. It's far more deferential to businesses than a non-compete that's done in the employment context. The rule is that the covenant must be reasonably necessary to protect the buyer's legitimate interest in the purchased asset. The reason for that is the protection of the goodwill of the business. That's what you purchased. You're not going to go out and spend a lot of money to acquire this business just to have the seller then go out and compete and exploit that goodwill that they had developed for years as part of that company to your detriment. So courts will be much more deferential when it comes to a non-compete in connection with the sale of a business. And all you have to do is compare it to the rule in the employment context, where it states that it has to be no broader than necessary. That's a tough standard. Reasonably necessary is much different. It's much more deferential. And just one example of that, when you're dealing with a non-compete in connection with the sale of a business, many times you get a 5-year restriction, right? Sometimes even broader than that. Like I said earlier, in the employment context, 1 or 2 years is going to be the max. So that's just one example of the ways that the courts are far more deferential to non-competes in this context. All right, so let's do just kind of hypothetical here. Let's assume that you have, and we'll do this in the employee context. You have an employee that leaves, has a non-compete, non-solicit. They go out, join a competitor. Day 1, they start competing against you. They're calling up your customers. They're moving customers. They're causing substantial harm to your business. You could say irreparable. So, you run to court and, you ask a court to, issue an injunction to stop them from violating the terms of the non-compete. What's going to happen? Well, a couple things could happen. There are 2 options in New York. The first is that a court could, what you call blue pencil the agreement, which is strike out what's overbroad and then enforce the rest. That's partial enforcement of your covenant. The second option is that a court, this is assuming obviously that your non-compete is overbroad in certain respects. The second thing a court could do is just invalidate the entire thing and say, you know what, employer, that's your fault. You drafted an overbroad covenant. I'm not going to enforce it all. All right, can move to the next slide. Well, right now, the way it stands in New York when it comes to overbroad covenants is that, it's the exception, not the rule, for a court to strike out what's overbroad and enforce the remainder. This used to be what courts did all the time, kind of finding the, what the parties, intended to do and reform the agreement in a way consistent with that and consistent with the applicable law. That used to be the rule. That is not the rule anymore. What courts are more and more likely to do, and this is the trend, go to the next slide. Courts are more likely at this point than ever to say, shame on you, employer. You controlled this agreement. You had the ability to draft a reasonable restriction. You didn't do it. You got greedy. So we're going to strike the entirety of your covenant. And this is the nightmare scenario where a court says we're not going to enforce any part of this. We're going to invalidate the entire thing, and we're going to leave you without any contractual protection whatsoever when it comes to your confidential and trade secret information and your customer relationships. And that's why it's paramount that you make sure that your agreements are consistent with the current state of the law, not the way the law existed 5 years ago, 10 years ago, 20 years ago. Because if you're utilizing stale restrictive covenants and you're utilizing the same restrictive covenant for every class of employee at your business, you're at risk of this nightmare scenario happening. Next slide, please. Fortunately, though, all is not lost. There is no reason to panic. Just because you may have an overbroad restriction in place now does not mean that you cannot fix it. Like I said, you need to take a look at these old covenants. Periodic reviews and updates are absolutely essential. And if you take a look at those covenants and realize, oh wow, I have something that's been around for 5, 10 years and I haven't updated it, there are many opportunities to do that, even with existing employees. They can be updated. This is similar to the consideration we went over earlier when it comes to a non-compete at the outset of employment, right? You could again rely on continued employment as a means to fix a non-compete. Again, there's more disfavor to that, but certainly, you could put down a new non-compete in front of employee and say, you have to sign this as a condition of your continued employment. But I think the better way to do this, and I think this is best practices, is whenever an employee is up for a promotion, whenever an employee is up for some sort of positive change in their terms and conditions of employment, even if it's just a small raise at the end of the year, use that as an opportunity to take a look at your non-competes again and make sure that they're compliant with the law. And now you can condition that raise, or maybe even put a small bonus on top of it, and condition that on them signing a new non-compete, non-solicit, non-disclosure. And finally, if you have a situation where you're terminating an employee, this is a great opportunity to make sure that the non-compete is going to be up to snuff. It's going to be consistent with the existing state of the law. If you're going to provide any kind of severance anyway, now you can go ahead and say, all right, well, not only, you're going to get the severance, but, as a condition of that, you're going to sign this new non-compete to give us better assurances that, one, you won't go ahead and compete, you won't solicit, and also knowing that now you're in a better spot to enforce in the event of a breach. So, that's kind of, what I want to talk about today, right? The use of the non-competes to preserve the value of the business. I know I've went over a lot in a very short period of time. So certainly if you have any questions, feel free to reach out to me, either via email or telephone. I'm always happy to talk more about this subject. But with that, I think I'm going to turn it over now to Seth Gilbertson, and he's going to talk to you a little bit about some other terms of employment agreements.
Thanks, Brad. Hi, everybody. I'm Seth Gilbertson, another partner here in the Bond Schoeneck King Buffalo office. Welcome. Thanks for coming this afternoon. I promise not to cover as much as Brad did and do so in less time. I do want to just point to that last little bit of information that Brad talked about, though, and note that it does essentially apply to all aspects of the employment agreement. Many of the things that we'll be talking about could be renegotiated if we talk about something. If I talk about something and you say, oh, you know what, I haven't been putting that in my past agreements and I'd really like to add it. You can always add that sort of at incremental points, landmarks along the way. Some of those points that Brad discussed where you're giving a raise or renewal or something, a term renewal, something like that. I'm also not going to talk about any of the information. I'm not going a big piece of any modern practitioner employment agreement would include all of the things that Brad just talked about. I'm obviously not going to talk about that piece today because he's already done so. Next slide, please. As a general matter, one of the things I want to emphasize is what the purpose of an employment agreement is. It is not It is not to restate all of your terms and conditions and policies applicable to employment. That's what your employment handbook is for. This is not to take the place of your employment handbook. It is to supplement the employment handbook with some specific information that is targeted towards the individual that you're agreeing with, that you're hiring or bringing on board, and to emphasize maybe some key pieces of the terms and conditions of employment that are already set forth in your handbook, I'll use handbook as sort of shorthand for all of your employment policies. We don't oftentimes keep an actual handbook anymore, but it may be all in a list of applicable employment policies and procedures. So you're supplementing that, not necessarily, and certainly not trying to recreate it in any way. Next slide, please. All right, so some of the things you're going to add that you may not have in your employment handbook because they're specific to the individual you're dealing with are the offer of employment. And oftentimes an employment agreement will be structured as sort of a letter laying out terms. And then at the bottom, we'll say, if you agree to these terms, sign here. So it's both sort of a statement of terms, letter, and an offer, as well as once it's agreed upon, it will serve as a contract essentially between your practice and the provider. And I am focused on providers here. Many of the things that I'm talking about today would apply to various types of employees, but we're going to focus on hiring providers because we know that's sort of one of the biggest areas and the I'll say riskiest endeavors that many practices engage in, and one of the sort of the highest leverage types of positions. So you're going to lay out compensation and benefits. Obviously, that's not the kind of thing that's going to be in your handbook because it's very specific to the individual. We'll talk about those in a little bit more detail in a minute. Duties and responsibilities, again, not something that's general, not the general types of terms and conditions that apply to everybody, but the specifics of the employment relationship that you're entering into with this individual, what you expect of them, schedule, location, which may be, sorry about that light here, which may be in many cases partially remote or hybrid, maybe between a clinic, an office, and there may be hospital hours or on-call hours and those kinds of things. So you want to be specific about those. The term, the duration of the employment. And it doesn't have to necessarily have a hard endpoint. It can be continued, but maybe it's a 1-year term with an optional agreement between the parties to extend the term by another year, by another 3 years, whatever it may be, applicable to the specific individual. And that's in the absence of the a use of a termination provision, which you're also going to have in there. Next slide, please. And again, all those are things I'm going to talk about in a little bit more detail here. So compensation structure is probably one of the most important things to get to set forth in an employment agreement. Probably one of the things that's most likely to lead to disputes in the future. And so you want to be extra clear and specific about exactly how the compensation is going to work. Don't take anything for granted. You want to put everything in there in defined terms. So if you're going to have productivity based, which many provider agreements do, you want to not only talk about levels of RVUs that are going to be met at certain benchmarks along the way, but how those are going to be calculated and what every specific number landmark that is reached is going to return. So don't just say every 10 gets you this. It's 10 gets you this, 20 gets you this, 30 gets you that. Just to sort of make it very simplistic. So how bonuses are going to be structured as opposed to base pay. And I put compliance with the Fair Labor Standards Act in here. That's not something that's often going to apply to physicians, for instance, but it may apply with regard to overtime wages, specifically with regard to some, for instance, mid-level providers or nurses, people like that. Next slide, please. All right, any types of benefits that may be included. Many of these are not going to be thoroughly defined in the employment agreement itself. Rather, this is one of those areas where I mentioned earlier, you're going to sort of highlight and emphasize some key terms that are already included elsewhere in your employment handbook or policy and procedures. You're not going to reset forth your entire health insurance policy and benefits package, but you're going to highlight some of the key, here's the package that you get. Here's what we pay for. Here's what you pay for. And then maybe provide a link or as an attachment or a reference to a more thoroughly documented place where your entire policy is laid out. Same thing with things like malpractice and tail coverage. You're not going to put forth the entire policy, but you're going to talk about what your coverage covers generally, what you're going to pay for, what you're going to, if anything, expect the employee to pay for. If there's going to be CME allowances, both in terms of time and payment, or travel expenses, things like that, you want to put those set forth. Same thing if there's any kind of research expectations or publications or anything, promotional activities, things like that that you expect or want the individual to engage in. Again, full descriptions of the benefit plans are going to be set forth elsewhere. This is really just a highlighting, and again, enough to inform the individual's decision as they enter into this agreement with you. So what would they want to know to make this basic decision, not to actually utilize the benefits? Next slide, please. All right, termination clauses is obviously another area where there's likely to be future disputes down the road, and you want to be very specific to the extent you can. Obviously, for cause is not so easy to define because you're not going to lay out every specific type of misconduct that could lead to termination, but you're going to generally discuss, what you consider to be appropriate practice, appropriate performance, and what would lead to a for-cause termination. Certainly, there are some things that you can be very specific about, like a loss of licensure or privileges or accreditation or something like that, where the individual is no longer able to engage in what you've the activities that you've hired them to engage in. Notice requirements, how many days, particularly if it's a not without cause termination. It could be 90 days, could be 30 days, something like that. If there are severance provisions, you want to say you need to give us X amount of notice and do the following things: turn over patient records, work on a transition plan, those kinds of things in order for you to be entitled to severance. So that oftentimes the consequence for noncompliance with those termination requirements would be loss of severance. Generally, you can't withhold wages as a result of that, but you could withhold bonuses and severance package. Next slide, please. All right, you want to set forth again basic the kinds of things that would be cause for termination or loss of benefits or loss of privileges or loss of bonus or things like that by setting forth workplace expectations, professional standards. A few of the things you want to make sure that you are specific that practitioners are to engage in reviews and investigations that may come through either the workplace, either the employer itself, or through a medicaid inspector general or something like that, or a discrimination investigation from the EEOC, that kind of thing. You want to have people agree that even after post-employment, they're going to continue to participate and voluntarily cooperate with those types of reviews and investigations. You just set forth certainly non-discrimination provisions are going to be in here. So again, some of the sort of highlights, obvious kinds of things, but things that you want to be specific about, be very clear about, so that people, when they're entering the employment relationship, they both know what is expected of them, and there are things you can easily and clearly point to without having to resort to a 120-page employment handbook or manual to say you violated this term of the agreement that we had. Next slide, please. All right, dispute and resolution mechanics. You're going to have something like that in there. Governing law jurisdiction. If there is if there are mediation or arbitration agreements in the that are going to dictate the terms of dispute resolution, should there be a problem with enforcement or compliance with the agreement. For the most part, you're going to try to arbitrate most matters. In many situations. Sexual harassment or other forms of discrimination, you can't arbitrate, you can't force into dispute resolution. in New York State. So just be aware of that, and don't even try to put them in there because it will reflect poorly upon you. We can always change those down the road if those laws change, but I don't see that happening anytime soon. Next slide, please. All right, confidentiality and intellectual property. These are provisions that are going to certainly survive the employment arrangement again. Obviously, you want HIPAA compliance. You want individuals that are trained to comply. They're going to keep up their training. They're going to comply with all your information security and data governance requirements, making sure that they're properly handling all your practice information. It's clear. It should be clear in these agreements who owns any kind of intellectual property that is created. It's generally going to be defined as a work for hire, so the employer owns it if the employee produces it during the term of their employment, and then that ownership interest survives the employment relationship. Next slide, please. All right, so again, we're not restating everything in the employee handbook. This isn't meant to be a kitchen sink approach. You're not throwing everything at it. You're picking out what are the crucial specific terms to this individual's employment, and what are some key things within the overall employment agreement, within all the policies and procedures that you have as an employer, that you want to emphasize in order to make sure that when the individual enters into the agreement, when the employee enters into the agreement, they're doing so with all of the material relevant information that they would need to make an informed decision, so that that's ultimately an enforceable agreement. You're balancing both the employee's needs to know this information with the practice's interests in making sure they set forth clear expectations, and again, incorporating existing policies. If you don't have those policies in place now is the time to do it. Don't worry about the employment agreement, because the handbook and the policies and procedures that are in that are much more important. If you're one of the many employers that we often work with that are sort of in the middle stages of a 3-year handbook review, now's the time to get that done. Nothing is more really important in terms of defining the employment relationship and protecting your interests as an employer than making sure you have routine updates of that employee handbook, and that it's as rock solid as it can possibly be. And then both from your side as the employer and the practitioner side, it's often wise to have legal review before signing this agreement. You often want to use counsel to help draft this agreement. It's very reasonable to expect the employee to want to have their counsel also review the agreement. And so you want to give time for them to be able to do that. In many cases, you may not be willing to negotiate a lot of the terms, but I would encourage you to, at the very least, hear back. Sometimes even just having a little bit of flexibility helps sort of lubricate the way into the employment relationship, and make sure that the person, when they show up on day one, they're happy, they feel like they got what they wanted, they feel like they have a good agreement and that they're where they want to be. All right, I think that's it for me today. Next slide, please. Oh, I guess I have one more. I'm sorry. I did just want to mention that I'm not going to talk about non-compete clauses. Don't worry. But in terms of value-based compensation models, almost every practitioner has some form of bonus tied to RVUs or performance tied to RVUs. We want to, again, make sure you're being very specific about how those are being calculated, what time frames you're looking at, and how those weigh in terms of general performance expectations like office hours, on-call hours, things like that. So you want to make sure you're dividing those things up, being very clear what the compensation model is going to be. And then the impact of telemedicine. If there are going to be, if you are hiring practitioners, for instance, in multi-jurisdictional environments where they're practicing both, at your place of business in, X city and X state, as well as maybe you're providing services to another city or another state. Sometimes, as Brad mentioned, in New York, we have different jurisdictions within the same state. So make sure you're setting forth all of the required licensures, trainings, CME requirements, all those kinds of things, and making sure that the individual is fully qualified and remains fully qualified to comply with all of those requirements. If there are technological or data maintenance requirements that the individual needs to comply with, they need to have a specific type of environment that they are going to be practicing when they're engaging in telemedicine. They need to have specific technology, those kinds of things. Set those forth now. Make sure they enter into those expectations. So again, or they enter into agreement with those expectations clear, so that they again are prepared to start on day one and feel good about where they are with things. Next slide, please. I think we're all set. Thank you, everyone.